Dear participants, dear friends, it is my pleasure to welcome you to our new global digital encounter dedicated to artificial intelligence, software, and patents. We created in May the cycle of global digital encounters that should enlighten us in reflecting on the challenges that the intellectual property system are to face due to basically the post-COVID world, or the COVID world and the post-COVID world. In doing this program, we have pulled our forces together, the Transatlantic Intellectual Property Academy, of which I am the coordinator, and the Fide Foundation in Spain. We have decided to work together in order to create a long-standing program with a series of encounters over the year, covering most aspects of intellectual property that we deem are necessary to be revisited in the light of the epidemics of the pandemic and of also the post-pandemic. As soon as this will happen, we will need to also adjust various focuses in the intellectual property world that has been really reshaped by the pandemic. We know not only in the field of patents, where we had issues connected with medicines, and we have so in the field of copyrights, where a massive use of digital networks is completely changing the face of copyrights. There is a third question among the three main questions that have been brought up at our initial encounter, and now we are already at the fifth one. And this third question is artificial intelligence, which pervades in all directions, in the directions of how it interacts with protection of patents and how it interacts also with copyright. We decided with the co-director of the academic co-director of these global digital encounters, we decided with Professor Desantes, who is co-director with me of this program, to dedicate 2 sessions to artificial intelligence. One connected to software and patents, and the other one connected to copyright. Today, we are at the first one. And at this very first one, organized, therefore, by Fide and TIPSA jointly, and with the support of many sponsors whom we really thank for this, we have decided that we would basically bring the best academics from all continents, and we gathered academics from China, as well as from the UK, but also other parts of the world where he comes from and has taught. So basically, we have gathered together Professor Yu and also Noam SHEMTOV from Queen Mary. So Professor Yu is a worldwide authority from China on intellectual property, one of the most authoritative professors there. And Dr. Noam SHEMTOV is one of the most authoritative and quoted authors in the field of intellectual property, teaching at Queen Mary University. In order to moderate them, we have invited an exceptional moderator, Dr. Marco Aleman, who is WIPO official, and actually WIPO senior official. He's director of the Patent Law Division. So supported by the international community, or at the request of the international community, it is his duty to shape the future of patent law. So nobody else than Marco Aleman could really help us shaping the debate and raising the right questions. The objective of this encounter is not to arrive with solutions that are already to be taken for granted. It is to reflect together, to progress together in order to make an advancement of knowledge. I thank the participants who come from all over the world. We have at today's encounter about 400 people who have registered, well, actually practically 500, from absolutely all continents, academics, professionals, researchers, and then students, and many of them work with us in their everyday life. I greet them warmly in this very occasion. I thank again strongly our partner Fide, partner of the Transatlantic IP Academy, and I thank also the co-director, Professor DeSantis, who organizes these events with me, so that we really share altogether better knowledge. I would wish to give the floor to Javier Fernandez Laschetti, also from Fide and El Saburu, who coordinates with us this program and would wish also to introduce the event and greet all of you in this activity. Remember, speakers would talk relatively shortly because there would be space, a large space for our public to interact. This is something we are constructing together from all over the world, a new, better, and interacted world. Thank you. Javier, the floor is yours.
Thank you, Laurent. And as usual, I wouldn't like to spend so much time talking because we have the best speakers today and the best moderator that we could have, Professor Yu, Professor SHEMTOV, and Dr. Aleman. Just to remind you, as I always do, that this is not a webinar. This is an encounter, and this means that we have encounters from time to time, but we belong to a community of people involved and interested in IP law. So you know that we have made some contributions. You can find documents that were posted by the speakers, and we will have more information. You can use it. You can share with others. You can share information with us if you find something that it could be interesting for the community. So thank you very much for attending this encounter. Thank you very much to the speakers and the moderator. And Marco, I think the floor is yours. Thank you.
Many thanks, and I would like to start thanking the two academic directors and Dr. Javier Fernandez Laschetti, the coordinator, for this kind of invitation to moderate. Let me, at the same time, congratulate both Laurent Manderiu and Professor Manuel DeSantis for this initiative of the Global Digital Encounter, very timely, very needed. So my best wishes for this forum to continue in the right direction as you have been doing so far. So today we have the fifth encounter on artificial intelligence, and the issues to develop will be software and patents, with the approach of the impact of emergencies like the one of COVID in this situation. So that's why it is called Toward a Post-COVID Changing Game. So in this occasion, we have the privilege of having top experts and academics from different regions of the world who will be able to present the subject with different perspective and with their own particular approach. In order to start, and with the intention of saving time and giving all the time to the speaker, allow me to give the floor to Professor Xian Yu for his presentation. Professor Xian Yu, you have the floor, please.
Thank you so much. Thank you, Marco. And it is my pleasure to be here. Thank you, all the organizers. I would like to say good evening, good morning, and good afternoon. Whenever the audience come from different part and different country area in the world. So now I would like to share with you my opinion. So today my topic is challenges of artificial intelligence to patent law and possible countermeasures. So in this presentation, there are three parts. Firstly, AI and its development. Second, challenges of AI to patent law. And then finally, I would like to suggest several possible solutions. So as you know, AI and the AI-related technologies are quickly developed these days. But when we use the AI technology suitably, the AI inventions should be the angel masterpiece. However, when we misuse the AI-related inventions, that should be the hand of devious. So although now in different areas, we have already benefit from the AI-related inventions, including the AI-created inventions and something else. But sometimes we're also facing dangers by the misusing. Here, for example, nowadays, worldwide, we are facing the epidemic of COVID-19. So it is very dangerous. And many countries and the technical groups try to find out more AI inventions. And the AI created by human beings also sometimes automatically do continue innovations and inventions, including data collection and the testing, vaccine, and diagnosing, treatment, different kinds of technology. But everyone wants to have the principle of fairness, safety, and ethics. So how to realize such kind of three most important principles? Whether we can suitably decide which kind of technology or AI-related inventions could be patentable, whether we should make compulsory license or the license of right to ensure the fairness, safety, and ethics. So actually, AI, this notion, has already mentioned in 1956, but only in recent 10 years, the AI-related inventions have been quickly increased and widely used. From the patent application and granting numbers, we can also see this tendency. Only in recent 10 years, it was quickly developed. Also in China, we have the AI-related plan beginning from 1980s, early 1980s. The AI technology was gradually developed, not so quick. But only since 2016, the Chinese government published Made in China 2025, combined with the Internet plus AI 3-year action plan. And recent years, we have the notice on the development plan of a new generation of AI, as well as want to establish so-called AI 2.0 by 2013 to promote China's high technology and industry development. Here are two examples. In 2016, AlphaGo successfully defeated Li Shisi and Ke Jie, becoming the first AI program to defeat the world champion of Go. In October 2017, Saudi Arabia awarded the robot Sophia citizenship produced by Hansen Robotics. That is the first robot who acquired citizenship in the history. And worldwide, some international organization published, enacted legislation and guidelines in recent years. For example, on April 8 last year, the European Commission presented ethics guidelines for artificial intelligence. So now the second part, we discuss the challenge of AI to the patent system. Mainly we will discuss three point: patentability, ownership, and infringement liability. So firstly, patentability. So it is still necessary to encourage AI-related inventions at the present weak AI stage. So here I would like to divide the AI stage into weak AI stage, current, or in the future, the strong AI stage. The difference is now in current weak AI stage, AI robotic if AI create an invention, still need the support and participant of mankind. In the future, when AI can independently create new invention without any support and participation of the human being, that will be the so-called strong AI stage. So I think in nowadays weak AI stage, we still need to encourage the human being, mankind, to create more AI-related inventions. So that means the AI-created technical solution should be in somehow with some precondition patentable. We can use the method of exclusion. That means we exclude the hand of the devourer, etc. For example, when the inventions contrary to public order, for example, the killer robots, should be excluded to be patentable, like the regulation in Chinese Patent Law, Article 5. Secondly, if invention, so-called invention, without technical solution, just fast algorithm or game rules based on data processing and enhancement algorithm, such kind of pure computer software can not be patentable, like the current regulation in, for example, Chinese Patent Law, Article 25. Thirdly, some inventions with unpredictability and potential irreversibility, for example, AI-related technologies combined with algorithms of machine bias or black box. So it is maybe dangerous when implemented, but still difficult to be decided which one has the dangerous, which one belongs to black box. So now the challenge one, how to recognize AI created invention is technical solution or just an algorithm. So if pure algorithm, no, not patentable. However, for the technical solution, should be patentable. For example, at least in 2013, Ruskin developed EVA, a robot which can, with the advantage of self-learning and automatic drug identification ability. This EVA robot found by more than 5,000 times experiment, found anti-cancer compounds. So that is really an invention. So can patentable. Challenge two is whether we need some special criteria of novelty, inventive steps, and practicability for AI-created inventions, which will be different from the inventions of mankind. So, novelty. If in the future, the patent law regulated strict standard, so maybe some breakthrough technology solutions could lose their patentability. But if the standard is too lower, could lead to lots of junk patents, also not good for the society. For creativity, when do the examination, how to define the so-called ordinary skilled person in the art, whether it also should include other AIs. So maybe now all the so-called ordinary skilled person is a human being, okay? In the future, when doing examination for the AI created invention, whether other AIs should be the ordinary skilled person in the art. Third, about the practicability. So how to recognize the beneficial and repeatability is also a problem need to be done in-depth research. Challenge 3, ownership. So if AI created invention is patentable, so who will be the patentee? AI itself? If AI itself will be a patentee, it is actually not suitable. It will be difficult to achieve the legislative purpose and the purpose of the patent law, because like, for example, in Chinese patent law, Article 1, it was regulated. Granting patent to a patentee is just a method to encourage the further invention. The final purpose is enhance the society, the public interest of the society. So actually the AI itself did not need any encouragement, and maybe it doesn't understand. Second, does the patent right belongs to the inventor or producer of the AI robot? Someone think, oh yes, because the AI was invented by the former inventor or producer, and they put the software into the AI. Therefore, the AI created invention also belongs to the former human inventor. But I think because the former inventor or producer just created the AI itself, if AI itself is patentable, such kind of patent right belongs to the inventor. However, when AI created a new invention, that should belongs to the owner or the user of the AI. Just like the employee invention, when belongs to the owner, a company who own the AI. So when someone maybe were discussed, maybe the user or a programmer use the AI, this person has also the inventive contribution. Therefore, the patent should belongs to the programmer who use or control the AI. That is also possible. That is so-called non-employee invention. And then come to the challenge 4 and 5 related to infringement liability and how to identify infringement. Because the characteristics of the patent infringement of AI-related technology has some specialty, including multi-stage implementation, indiscoverable, and multi-agent implementation. We take the cloud computing as an example. In cloud computing technology, there are at least 5 participants, 5 stages, including platform providers, system integrators, service providers, application developers, and users. So if there are several patents or one patent has a full or a little bit complicated technical solution, technical features, and each part only implemented a part of the whole technology. So that means no one belongs to the direct infringer. In such kind of situation, that means if there are only indirect infringers by different infringers, there are only indirect infringements by different infringers, whether patent infringement would be constituted. About this problem in the CAFC in the US at the beginning stage 2007, the judgment is no infringement happened because indirect infringements is based on direct infringement. But recent years, for example, in 2015, in the case Limelite, although there are no direct infringement, however, all participants, all so-called indirect infringers are infringer. So the court decided even without so-called full cover, the technical feature, the direct infringement also existed. Or simply to say, even without the traditional direct infringement, the indirect infringement are also infringement. So finally, I would like to suggest some possible solution to AI-created inventions. So firstly, public property. And is there any new sui generis right? And whether we need to change the regulations about primary rights in patent law. So firstly, about public property. I think at least in the current weak AI stage, public property should not be a good solution for AI-created invention, because otherwise mankind or other AI will imitate this kind of invention lawfully. It is not good for encourage further invention and innovation. But in the future strong AI stage, when the AI can independently create new inventions, it could be one possible solution. Second, whether some new sui generis rights are needed. I think in the weak AI stage, it seems still not necessary to increase new sui generis rights for AI-created inventions. But researchers need to do for considering possible sui generis right in the future strong AI stage. Finally, whether we need to change the regulations about primary right in patent law. I think even in this weak AI stage, for patent law in the restrictive provisions for patentability, like for example in Chinese Patent Law Article 5, it is already necessary to increase safety and ethics regulations for AI-related technologies. That means when the AI-created inventions, even AI-related inventions, are not good for safety and aesthetic regulations, such kind of invention should be excluded from the patentable subject matters. So I think my time is almost over. Thank you very much for your attention. Thank you.
You are very kind, Professor Yu, for this excellent and very clear.
Yes, Marco, I'm sorry to interrupt. If you could please turn on your camera so that I could send you live.
Yeah. Yes, Professor. Professor Yu, many thanks for very kind. and useful presentation. We do have a few minutes for questions and answers.
Yes.
And I will be more than glad to take a few questions from the audience if those questions exist. So feel free to send those questions through the chat that is already available for you to send questions. And my colleagues and I will be attentive to read those questions out. So please, those members of the audience that have any questions, send those questions to us. In the meantime, and taking advantage of my role of moderator while other questions arrive, allow me to mention the following, Professor. Among you proposals, and that will be probably a question to break the ice and give the audience the chance to ask. In your proposal, when you mention that public property is probably not a good solution at this weak stage of artificial intelligence, and it could be probably that in a later stage, it may be an option for consideration. Would you mind to tell me if it goes to the public property option, what would be the incentive that would exist for innovators in the area of artificial intelligence? What would replace the incentive we have of the appropriability via patents? And then I will be, while you are elaborating on this, I will be taking the question from the audience. Is that okay?
Yes, thank you. So actually, my opinion is in current weak AI stage, the public property solution is not good. Now we need still granting patent to the AI owner, the patent right. So to encourage the continued invention, but in the future strong AI stage, the public property approach is good because at that time, AI can independently do many invention. So if we continue to grant patent to AI or the AI owners, so there are so many patents. So the society, many companies cannot implement the technologies easily. So that prevent the new technology development. And there are so many patents, the AI invention gradually easier and easier. And the invention is much and much. So at that time, although the patent law can grant a so-called patent right to the owner of AI or even AI itself. However, all public can use it for free.
Excellent.
So, yes, thank you.
Excellent, Professor. So we have one question here. Allow me to read. Yes. One of the participants says, in England, only this week, September 21, the High Court has rejected the idea the artificial intelligence machine can qualify as inventors under the English Patent Act of 1977 in a case under the identification Tale versus the Controller General of Patent Designs and Trademark. So it is a comment rather than a question, but probably will be good to elaborate on that because it goes in line of the opinions you advance in your presentation.
Yes, very good question and very good case. I also support the judgment because actually should be better. So You mean the inventor could be AI or not? Okay. Patentee should be the owner of the AI, but inventor could be the AI itself. I think, yes. Because in the future, we can continue to discuss the copyright. And the AI could be the order, but the copyright ownership belongs to the owner of the AI. That is my opinion. Thank you.
Excellent. There is another question here, Professor Yu. One of the participants says the following: I think you didn't mention the issue of sufficiency of disclosure. You went through the issue when you mentioned the black box as an issue, and normally black box represent a great challenge for the requirement of sufficiency of disclosure. So probably what the participant is asking a little bit more of elaboration on the sufficiency of disclosure requirement in patent law and how it triggers some challenge for artificial intelligence related inventions.
So this is also a very good question. Thank you. Actually, we are now organized an interdisciplinary research team, combine patent experts together with the AI experts come from the School of AI of our university. We do in-depth interdisciplinary research. Actually, the AI technology are gradually complicated in this stage. So for us, the patent expert sometimes cannot understand in depth. That means even some technical solution or technical features seems to be disclosed in the patent application document. However, the public, even sometimes the examiner, cannot recognize whether that still have some black box. Black box does not mean the invention did not disclose. Just because such kind of technical solution, when implemented, has dangerous result in the future. Before implemented, no one knows whether it still have some black box. So black box does not equal to non-disclosure. Thank you.
Good. Regrettably, we exhausted the time available. There are a number of other questions that probably will keep one of those in our box of questions that we can use in the next presentation. So please join me in applauding this excellent presentation of Professor Yu. Thanks for that. And then now I pass the floor to Professor Noam SHEMTOV. Professor SHEMTOV, you have the floor, please.
Thank you.
Thank you, Dr. Aleman, and thank you, Xiang Yu, for this excellent presentation. And I would also like to thank both Laurent and Manuel de Santos for organizing this fantastic event. Now, I think Laurent mentioned before that this is not a webinar. It is more of a conversation, and this is indeed my intention. And my intention is to indeed have a conversation and share some of my thoughts on actually similar issues that were raised by Xiang before, but present or share them from my personal angle. And I would divide my conversation, if you would like, to two parts. First, I would look at the question of entitlement to the patent, where you find a lot of the debate today. I guess because it's more exciting. I personally think that from a legal perspective, at least for the time being, these questions or issues are settled. And then would move on to questions of eligibility and patentability, where I think we do have some real issues that need to be considered when it comes to the impact of AI technology on patent law. I will share with you very, very briefly some of my thoughts in that regard. I will not offer any conclusions as in solutions or recommendations within the short time frame that we have, but there's plenty out there, amongst others by myself, where you can get into a more in-depth analysis of some of those things that I would be referring to. So I will start with the entitlement. And Xianga, in his previous presentation, referred to strong AI and weak AI. There are various definitions out there. I think that when it comes to AI, before we actually think about strong or weak, I think most of us will accept that what we are talking about here is really a broad area of computer science. In our context, it's mainly about deep learning or machine learning, which are subsets of artificial intelligence that make machines or render machines look or come across as though they have human intelligence. And one fairly common or popular categorization is narrow AI. This is the weak AI that we have today, where we have an AI system that is programmed to perform one or a set of related tasks, single tasks or related tasks. And that is what we have today. Artificial general intelligence, sometimes referred to as strong AI. Here we are talking about something that can successfully perform any intellectual tasks that a human can perform. And for the time being, as well as for the foreseeable future, this is the sort of AI that we see and we continue to see only in movies. So when we move from narrow AI to general AI, we move practically from science to science fiction. And then there is another category, even above that, which some refer to as artificial superintelligence, so intellect that greatly exceeds the cognitive performance of humans in virtually all domains. So I would like to keep our conversation to the here and now, as well as to the foreseeable future, and therefore discuss the impact and the potential impact of weak artificial intelligence or narrow artificial intelligence on our patent law regime. And now, about a year and a half ago, I published a study that we prepared for the EPO. The study was commissioned by the European Patent Office on the impact of artificial intelligence technology on patent law, but in particular on the question of entitlement, inventorship, and ownership. I will, for time reasons, related reasons, I will leave the question of ownership aside. Again, that the study is there, but and I would focus really on the question of inventorship. I mean, inventorship essentially is the first stop in an ownership inquiry in any event. And the study really looked at two main questions. I mean, there were a number of other ancillary questions, but two main questions. One, can artificial intelligence be designated as an inventor? Remember, that was prior to all those cases that we have before us now, including the High Court decision on the appeal that was mentioned here in one of the questions. So first, could we designate AI as an inventor in a patent application? And the second one was, should AI be designated as an inventor? So in case the answer to the could is no, then the next one is, should we change the law, the legal position, and should we recognize AI as an inventor? And when we looked at those questions, we examined the legal position in what we identified as the key jurisdictions, key patent jurisdictions around the world. So we looked at the IP5. Those of you who are less familiar with the term, IP5 and the 5 intellectual property most 5 heavy hitters, if you would like, in the heavy hitters in terms of jurisdictions when it comes to patent offices. So you would have the usual suspect: the United States, China, Japan, South Korea, and the European Patent Office. We looked at all these jurisdictions. When it comes to the European Patent Office, the European Patent Office does not have a set of rules that defines who is the inventor. That is delegated to the signatory states to the European Patent Conventions, and therefore we looked at a number of key jurisdictions within the European Patent Conventions. We looked at Germany, France, Switzerland, and United Kingdom. So overall, 8 key jurisdictions. And we found that across the board, whether by explicit mention or by implication, an inventor, we're not referring here to owners, an inventor must be a natural person, should be a natural person. And as I said, whether there were explicit indications in either the law or in the jurisprudence to a natural person, or by implications, we found that that was indeed the case. And hence, the conclusion, after looking at all of those jurisdictions, the legal code and the case law, the conclusion was that an AI system cannot be identified. So if you would identify an AI system as an inventor, the application is likely to be refused. At that point, the study moved to the second question that I mentioned, and that is, well, if that's the case, is that a problem? Should that be addressed? Should the law be reconsidered so that AI systems would be capable of being identified as an inventor? And the answer to this, so let me cut the suspense here and say that the answer to this question was no. There was just no need. We looked at the reasons as to why we identify individuals as inventors. For example, say you work for a large company, a conglomerate, say IBM, irrespective of the fact that IBM would be the applicant, irrespective of the fact that IBM would be the owner, there is still an obligation to identify the person, a human agent, as we found, as an inventor. And that is done for a variety of reasons. There are a number of sets of rationale according to which there is the obligation to identify the individual as an inventor is there. And when we looked at it, none of those rationales applied or was applicable to AI. So when you try to apply those rationale to an AI system, it just didn't fit. It made absolutely no sense. Now, there is another argument out there which goes more or less according to this. Since we have inventions with where a creative AI, artificial intelligence system is involved, we need to identify the AI in question as an inventor because there is no human inventor. The invention is made, generated, whichever phraseology you wish to use, by an artificial intelligence system. And if we do not allow the identification of an AI system as an inventor, and since there are no human inventors involved because everything important was done by an AI system, we would end up with inventions which are inventorless, and therefore those inventions would not be able to benefit from protection under our patent regime. Now, when we looked at that, we reached the conclusion that there is just no evidence whatsoever to suggest that there are such inventions out there. There are indeed inventions where AI played not only a major role, but a key role. There are inventions where, but for the AI in question, you would not have the invention. The big leap, the big jump, the big push that differentiates the invention from the state of the art can be attributed to a large extent to an AI. But nevertheless, according to our current rules on inventorship, and that applies to all the 8 jurisdictions that I've mentioned across the globe, you will always be able to identify a human agent as an inventor. Always. So those inventions where there was heavy involvement of AI are still going to have a human agent as an inventor that we would be able to identify. And if that's the case, then they will be protected under our patent system. So you don't have, at the present state of affairs, that is. Now, Xiang mentioned strong AI, then that may force us to reconsider our position, and I agree. But until and unless we get to that point, we can identify human inventors, and therefore those inventions would benefit from patent protection. There is absolutely no benefit from at present from identifying a particular AI system as an inventor. As I said, the reasons for identifying John Smith as an employee of IBM and the rationale for doing so is just not applicable to artificial intelligence. For that reason, AI at present and in the foreseeable future, that was our conclusion, should not be designated as an inventor. And I can also share with you some of my thoughts, and that was not part of the study, as to what if. So what if we get to a point where a cognitive capacity of AI system is such where we will have inventions with no human inventor, right? It would be really run under the control of an AI system without a human inventor. What then? So again, we are playing it with what and if, and I always think that we should come up with a legal solution to a legal problem where we're actually facing the problem and we know what's the shape and the size of the problem in question. But if I'm forced to play with what and if, I would say that in that case, the debate should be quite different. First of all, the debate would be whether such a thing should be protected under patent law to start with. And I'm not expressing an opinion. I'm just saying that there are views out there that under such circumstances, patent law may not be the correct vehicle for protecting innovation, which is generated purely by, let's call it a machine or an AI system. That is not to say that it should not be protected or rewarded, but that may not be, but patent law itself may not be the right vehicle for doing so. But I would go one step further and say, let's say that we had this socio-economical debate. And let's say that we reached a conclusion, an informed conclusion, that it is indeed patent law rather than a newly created sui generis right, which may be suitable or adequate for doing so. I would say that even under such circumstances, there is little reason to consider the designation of a particular AI system as an inventor. Maybe we should have another class of patents under these circumstances where we don't need to identify the inventor. And when you see such a class of patent before you, you realize that you don't have a human inventor, and what you have here is something that has been created or developed without the contribution of human inventor. In other words, it's an AI system. But I'm yet to be convinced that there is a particular reason to identify specifically Watson from IBM or Santos from Nicaragua or whichever other AI system that we may have. That just adds complexity, which I, for one, cannot see the benefit of. Not to mention that it would require some internationally recognized system for registering AI and identifying AI and so on. So That's my 2 pennies worth on that particular point. Now, I'll also touch very briefly on the question. I can see that I'm running out of time. My time is up almost, on eligibility and patentability. And here I think it's worthwhile to separate between two. We get confused sometimes between two very different scenarios. When we talk about eligibility, what is and what is not technical, I think this is a debate that we can and we probably should, and some jurisdiction have already at present. But this is about AI-related inventions. So again, this is not about AI-assisted inventions, but this is where the AI system itself is the subject matter of your patent application. And if you look, for example, at the European Patent Office guidelines for examiners on artificial intelligence and machine learning, you can find some useful examples which are designed to caution examiners as to what may and what may not be considered as technical, which we know is a very important term or concept for the purpose of eligibility under the European Patent Office system. So that is an important thing that we need to take into consideration. Now, leaving the patentability of AI system itself, of AI systems themselves, and moving back again to AI-assisted inventions, that is, inventions in the process of which AI played a major role. Here we have some interesting questions in relation to inventive step, as Xiang mentioned. Who is the person skilled in the art under such circumstances, right? Well, we know that the person skilled in the art can also be a team of researchers, depending on the discipline in question. So who is the person skilled in the art in relation to an AI element of the invention-making process? What is their capacity? What does it mean to have capacity for routine and normal work in the field? Would the person skilled in the art use AI in a particular set of circumstances? Is AI part of the state of the art? Which AI-related know-how can be taken to be part of a common general knowledge, and so on and so forth? So these are all questions that we need to ask now, but they do not necessarily need or require any major changes for the law. We just use the same concepts that we always used. We just adjust them internally in our mind to a scenario where AI is becoming more and more prevalent in invention-making processes. And then, and one of those questions that were asked earlier actually pertain to that. There are some other questions in relation, and again, I'm going back, I'm flipping between the two. Again, here it's about the patentability of AI systems themselves. And here there are some interesting questions concerning enablement or sufficiency, if you would like, of AI inventions. That refers to what some people describe as black box, or the concept of explainability or lack thereof, lack of explainability in the case of some AI related inventions. And I believe that with that, I have come to the end, because my time is up. So thank you very much.
Excellent, Professor SHEMTOV, and great presentation. To the point in both cases, the distinction between eligibility and patentability, to the point, and the difference in between inventorship and ownership as relevant points, both in artificial intelligence, particularly on patent law and artificial intelligence. So let's go into a number of questions we have received that certainly touch upon the issues you just mentioned before. The first question is, can then a robot be an inventor? Something that you already described very well, but probably the participants would like some more elaboration there.
So the answer, the short answer, the very short answer is no. And the slightly longer answer is, as a matter of law, now it cannot be. I mean, the case that some of the participants was referring to from 3 days ago, I believe, suggests that an AI system cannot be designated as an inventor under UK law, and I am of the view that you would get exactly the same outcome when you try, if you try the same thing in all major or mature IP jurisdiction. And I would go one step further, and I would say, as I was suggesting or alluding to, not only that it cannot be an inventor, there is no reason to consider a change of the law that it should be considered as an inventor under the current state of play.
Clear, clear. Second question. The point of the question is, how does, or how it may work, identifying the inventorship issue in relation to the data, the amount of data or the data sets or the data that is used for the training of the artificial intelligence, how it plays a role in the identification of inventorship?
I think it's an excellent question, and I guess what the person posing the question was referring to is to what extent we can consider as an inventor the person who is responsible for the data trainer, in other words. And I think that, first of all, who is the inventor in some of those scenarios? It may be a complex question, as we sometimes have today complex questions when you have very large team of researchers with various inputs to the inventing process. But I do think that sometimes, indeed, I think Xiang was referring to it, that it is not the person that came up with the AI system itself, so came up with the algorithms and the relationship between them, but it's the user, and the user can be the data trainer, because data training is one of those phases where you really have the invention, the final outcome in mind, and you train and you optimize and you tweak and you optimize. And I can see how under certain circumstances a data trainer could be considered as an inventor or the co-inventor in such an invention-making process.
Excellent. And the last question would be the following. Do you think that artificial intelligence-generated invention need any sort of incentive, or could they very well fall under the so-called negative IP spaces?
So I'm going to assume here that the question, I mean, please correct me if I misunderstood the question, at least in your view. So this is whether we need to incentivize the creation of invention with the assistance of AI or the creation of AI systems themselves. I'm just not completely sure here.
In my view, the point of the question is, do patents needed to promote incentive in the case of artificial intelligence invention, or whether there is no need of IP? That's why there is no IP.
No, I think that patents are needed to promote in the investment, the effort coming up with new inventions, whether or not AI is involved in. I don't think AI changes the equation here, in other words.
Absolutely. Well, many thanks to both of you. Excellent presentation. I'm sure participants as well as myself are extremely pleased with the clarity and the way you develop the subject from different perspectives. Allow me to mention two elements that in my view are common. Both mention that patents plays a role in order to encourage innovation in the area of artificial intelligence. And because of that, either we call it in a weak stage or not, what is clear is more innovation is needed, and there will be great progress coming, and society will benefit significantly from the innovation in that path. So certainly patents play a role and has a positive impact on the innovation in the artificial intelligence field. But at the same time, it's clear that what is happening today, in many occasions, use inventions that are artificial intelligence related in different areas, like in training data, computational power, applications, neural architecture, robustness of the system, but not necessarily that much in the case of inventions that are invented really fully, totally from a given artificial intelligence machine. And if this is really happening, then certainly patent rules will not allow that those artificial intelligence machines be identified as inventors, because we need, in the current patent regime, and you conclude both that there are no need for changes at this stage, we should consider that there is a need to identify the human person involved in the invention for this to be the true inventor. And that is a great coincidence in between both of the speakers. So the inventorship issue so far mainly bring us to the conclusion that the current legal situation can bring solutions to the needs of the system. And if it changes in the future, we will see in which direction it has to be. And then in that sense, I will just conclude with these two main conclusions, in which I will call for certain caution in the issue of how to use the exclusion from patentability, because the overuse of the exclusion may close the door for innovation in this field. But I will leave in the air the idea of a special consideration in the exclusion of patentability that call Professor Yu on ethics and moral consideration, an exclusion that already exists in many jurisdictions and probably needs certain special interpretation in this field. Without any other comment from my side, I pass the floor to Professor De Santis, that I'm sure will give a closing remark to the speakers and the audience, to all of you. Professor De Santis, you have the floor.
Thanks very much, dear Marco. We do appreciate your skills as a moderator, but mostly today, because we know that today you are in one of the most demanding weeks of the year. Yeah, you are in the middle of the General Assembly of WIPO. A General Assembly, by the way, which also marks a new era with a new General Director. So please send our warmest regards to our friends Francis Garry and Darren Tang. Thank you, Marco. Dear Xiang, my brother, we are very grateful to you. Your presentation has been magnificent. When listening to you, I realize until what extent we need to listen more what Chinese scholars are proposing in all matters related to intellectual property, but most especially in these matters. In these matters where the leadership of China is more than evident. Yeah. It is very appealing, for instance, the distinction between a stage, weak and strong IP stage. Yeah. Many things are going to change dramatically in the IP world in the following years, and China is at the very, very head front. So dear Noam, it is always very rewarding listening to you. We could have spent 1 hour more moving from one issue to another, and we would have been enjoying. It has been a great honor for us having you. And also, let me say that it has been also a great honor for the first time having a representative of Queen Mary University of London today with us. Yeah. Thanks, Noam, for having accepted to think with us and to become part of the Encounters family. Yeah. And also many thanks to my dear friend, Professor Laurent Mandereux. Laurent, you are the father of these encounters, and we are very, very recognized to you. More and more, the encounters are recognized as a common place where scholars, professionals, civil servants, and students share knowledge, yeah, and reflect all our common future challenges. By the way, I would like also to mention, especially today, and recall all the students from Bocconi University who are massively following the encounter month by month, hundreds of them. So it is time to close this wonderful encounter by recalling you that we will have 3 other encounters before the end of the year. The topics will be amazing, certainly at the very heart of the future of intellectual property. For trademark lovers, it is a pleasure for me to announce that next October 30, we will develop the topic trademarks as a business tool towards a new rebound. So we will attack trademarks for the first time in the encounters. It was time. In November 18, we will address the other side of the coin of the topic we have developed today. As Professor Manderieu mentioned at the beginning, mainly artificial intelligence and copyright. And December 3rd, we will close the year with our 8th encounter, which will deal with trade secrets. My dear friends, it is time to close. Thanks indeed to our speakers, to our moderator. Thanks to Laurent Manderieu. Thanks to Javier Fernandez Laschetti. Thanks to Fide, but most especially, I would like to thank Álvaro Arribas, who is our technical master. Without him, we will not be able to be with you encounter after encounter without failing. And of course, thanks very much to all of you for being here today. So if Professor Manderieu allows me, I will close for today, and I will tell you bye-bye and give the floor to Professor Manderieu if he wants to say something. If it's not, we have committed to finish in 1 hour, 15 minutes, as we said before, and we wait for you on October 30 for trademarks as a business tool towards a new rebound. See you next time, and thank you for being here. Bye-bye.